Mr. President, today I rise to speak in support of the President's Supreme Court nominee, Judge Neil Gorsuch, who right now is about two-thirds through his second day of hearings, better described perhaps as a grilling. Simply put, I think that the President made an extraordinary selection. Currently, Judge Gorsuch serves on the Court of Appeals for the 10th Circuit, which includes my home state of Kansas. Our state has seen firsthand how Judge Gorsuch interprets the law. He has had an outstanding judicial record while serving on the court. What's more, he is highly respected and supported by individuals in the judicial community who align on all sides of the political spectrum, except, inexplicably, the United States Senate. Judge Gorsuch's qualifications are not only noteworthy, but extremely impressive. He graduated from Columbia University and Harvard Law School. He received a doctorate in legal philosophy from Oxford as a recipient of the Marshall Scholarship, one of the most prestigious scholar programs in the country. He has litigation experience from his time as a law partner, and he is clerk for not one, but two Supreme Court justices. Examining his record during his time on the 10th Circuit gives us some insight into the judge's approach to interpreting the law. When we read his opinions, we know he is a judge who follows the law, applying the text of the Constitution and statutes impartially. Of primordial importance to this body is his critique of the executive branch's tendency to assume the roles of the judicial and legislative branches. No matter which political party controls the executive branch, this body, the Senate of the United States, must protect its ability to legislate and create laws. The Founding Fathers intended for the separation of powers to remain inviolate. Judge Gorsuch understands the role of the judicial branch and the significance of maintaining that balance of power. He has made it absolutely clear he will not legislate from the bench. I repeat, he has made it clear he will not legislate from the bench, and that might just be the problem for those who would like to vote for a judge who would legislate from the bench. I, along with many of my colleagues here in the Senate today, confirmed Judge Gorsuch over 10 years ago. Judge Gorsuch's record was so non-controversial, the Senate unanimously supported his nomination. That includes the minority leader, Mr. Schumer, Senator Schumer, and then Senators Obama, Clinton, and Biden. I repeat, Judge Gorsuch has received support from across the entire political spectrum. His judicial record over the past 10 years has made him even more deserving of the Senate's full support. Now, the American people went to the polls in November, knowing the next president would have the distinct honor of nominating the next Supreme Court justice. And the American people have spoken. As the Senate, it is now our responsibility to see through this nomination and appoint the judge to the High Court. The Wall Street Journal summed up what is happening within its editorial pages today in pointing out senators want Judge Gorsuch to declare how he would vote in specific areas of the law, questions that every Supreme Court nominee declines to answer. Quoting from the editorial, at the 1967 hearings for Thurgood Marshall, then Senator Edward Kennedy called it a sound legal precedent that any nominee for the Supreme Court would have to defer any comments on any matters which are either before the court or very likely to appear before the court. The Journal's editorial went on to say that in the 1993 confirmation hearings, Judge Ruth Bader Ginsburg emphasized, quote, "A judge sworn to decide impartially can offer no forecast, no hints for that would show not only disregard for the specifics of that particular case, it would also display disdain for the entire judicial process. I regret to say that profound advice apparently does not apply today. One of my colleagues serving on the Judiciary Committee pretty well summed up the dilemma we have in the Senate when he said to the judge, if you fail to be explicit and forthcoming, the committee would have to assume your views are in line with Mr. Trump's. And you know there's the rub. Judge Gorsuch has written 789 opinions with only 15 dissents from other judges. The apparent burr in the majority saddle, the minority saddle, the Democrat saddle, has nothing to do with Judge Gorsuch or his qualifications. The problem is Mr. Trump is now President Trump. Why? My question is, all right, we know you feel that way. Every committee hearing that we have, we know you feel that way. When will this end? When will we get back to what is referred as regular order? That question lies squarely with my colleagues in the minority. I am really disheartened to hear the rhetoric coming from across the aisle in the days since the new president took office. The minority has taken extraordinary lengths to extend the confirmation process of the president's nominees. From shying away from our constitutional responsibilities and not voting on nominees in committee hearings to using unprecedented amounts of time to speak on this floor, disapproving of the president and his nominees, or anything else. These tactics are unbefitting of the world's greatest deliberative body. We have fallen from bipartisan deliberation worthy of public opinion and support to engaging with poisonous arrows of political procrastination. With the nomination of Judge Gorsuch, we now have an opportunity to fix this sorry state of affairs. This is the opportunity that we should seize to restore comity to the United States Senate. The people of this great nation deserve nothing else. I am hopeful that the minority will recognize the superlative qualities Judge Neil Gorsuch possesses and provide him with a fair and swift confirmation process. That's not happening as of today. But hope springs eternal, even within the United States Senate as it now exists. I yield back.